Seriously? Hello, everyone. I'm JustHearMeowt. Welcome to my channel, blah, 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 blah. Let's talk about day 9 of the Brian Walshe trial and how he has wasted more than a week of my time at this point. Let's go. Hello, everyone. Yeah, we went with the early stream instead of the late stream because it was so short. Suma is doing her own live right now. I was going to redirect to her, but her redirect privileges are off that I see, so I can't do that. But yeah, this was disappointing to say the least. I don't understand. So we're just going to watch the first few minutes here, which has the defense saying they're resting their case, and then we'll after that, I'm going to give my thoughts on if they prove first-degree murder, second-degree, whatever, and then we'll watch some of the the jury questions, not jury questions, jury instruction debate for the end, because that's, I think, the only real interesting part besides them going over the jury instructions in the middle. All right, so thank you to everyone who's here, and don't forget to hit the like button, and hello to the replay crew.
Good morning, Your Honor. Tracy Cusick with the Commonwealth.
Good morning, Your Honor. Good morning, everyone.
So listen to how disappointed he sounds, because obviously this was a surprise, or not a surprise, a change overnight.
Everyone, Kelly Porges on behalf of Mr. Walshe.
Morning, Your Honor. Larry Tippett, Mr. Walshe.
Morning. We need the defense.
Like he barely gets his name out.
All right. At the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walshe today. As an initial matter, does the defense still intend to call Mr. Walshe today?
We do not.
So they raised 5 issues last night for the judge to research.
You do not? Right? Does that move every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. I will conduct a colloquy with the defendant then now, and my intention is the defense intend to call any other witness.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record.
So I thought this was interesting calling it out because this is the way I remembered it, right? But it was reversed from what everyone thought. The prosecution did not want the charges that he pled guilty to introduced to the jury because they don't want it saying, well, are you aware that he already pled guilty to dismemberment, right? Providing like, okay, yeah, he did cut her up, but he didn't murder her. So the Commonwealth said, no, you can't put that in there. What does it have to do with the charge of murder? So the Commonwealth didn't want it out there, which, as I've been saying over the past couple of days, I think makes it look worse for the defendant. The defense wanted to be able to argue it.
So the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this
And I don't have all the labels all over this because I did, but this is 150% speed.
court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously, I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion to eliminate to exclude evidence that the defendant pled guilty to misleading the police into Anna Walshe's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for 2 reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do it.
So they filed a motion to try and get it in there without him testifying, because the defense wants that in.
Anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial.
Yeah, it did.
And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the 2 charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of the sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding an Abe juvenile applies with equal force. If the defense was permitted to tell the jury that he pled guilty to the two lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferreira, 373 Mass 116, 124, 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others.
Absolutely, quirky blonde princess. Hours of hilarious content have been stolen from us.
Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter. And Madam Clerk alerted me to also file this morning 321 pause. Commonwealth supplemental motion to eliminate to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light
I
of
think
my
it's
ruling.
moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay. So just so the record's clear, when I said a moment ago, I did review what the defendant filed this morning. It's just not 216, it's 318 on the docket. All right, I see that I have two other pleadings up here, which I will address in brief. One of them I was going to address anyway. It's in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe, Attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying, he promised you something in the opening statement that he didn't deliver.
That's right. And after consulting with the Commonwealth's client, they have no intention, they've told us they have no intention of doing that.
So a motion saying that the Commonwealth cannot say that we didn't deliver something that we mentioned in our opening statement.
I have already pulled out some case law on this and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit of my research on that issue. The other motion, 320, is I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that. So now I do want to conduct a colloquy with the defendant at this point.
The pretend judge, do you know how much time he would get if he is only pleading guilty to dismemberment plus his pending scam charges? Hopefully, either way, the jury goes he will be guilty. So I know he's sentenced to 37 months on his scam charges. I don't think there's any parole because they're federal charges. So that'd be 37 months, so just over 3 years. I know that with the dismemberment stuff, it matters on what the outcome of this is if it's a felony charge. So if he's found guilty of this, he can get up to 20 years. Let's say he's found guilty of either first degree or second degree murder. I think that allows the charge of the dismemberment, because it's in connection with the crime, to be up to 20 years. Otherwise, the minimum is 10 years. So if he is not guilty on everything right here, he's at least 13 years. I don't see why the judge wouldn't put the 10 years consecutive to the 37 months, because they have nothing to do with each other. They're totally different crimes. Let's say if he was convicted of first degree murder, that's life without parole. No, he's in there forever. It doesn't really matter. If he's second degree, it's life, but a potential for parole after 20 or 30 years. I don't remember, but I don't see why the argument couldn't be made that the pled guilty for dismemberment and lying to cops shouldn't be consecutive to that. Those are subsequent crimes after a murder. Murder doesn't require the dismemberment of the body. That is a separate charge. So, but I'll give my thoughts on what I think they can prove.
Would you like me sworn, Your Honor?
Hold on a second, because I'm not sure I have my
So we're going to do the colloquy of Brian here. The only time we get to hear him testify.
Colloquy with me on the bench.
Mr. Walsh, if you could stand and raise your right hand, please. Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing to be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing, so help you God?
I do.
Thank you.
Excuse me.
You can be seated. I just didn't, I was wondering if you were asking me if I wanted him over on the witness stand. I do not. Mr. Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing?
Whether I'll testify or not in my trial.
Right. Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
Almost all downside, but then again, where's the upside of not testifying since the evidence is out there? At this point, they've got to be playing for, hoping for second degree, which gives them some chance of parole. They're just trying to avoid first degree at this point, or they actually think they can get him not guilty.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
Which is interesting. I wonder if, since the defense was putting all those motions in, is this Brian's decision? Like, is this one of those weird instances where the defense attorneys need him to testify and then he's like, no, I'm not gonna? Or was this a decision made after seeing how well the witnesses were on the stand yesterday? Just put the prosecution part aside for a second, right? Even on direct, is Brian going to be able to match that delivery of emotion that the two witnesses yesterday did, even just thinking about Anna? I don't think so.
No, Your Honor.
No, Your Honor.
I find that the defendant, Brian Walsh, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision.
So then they bring the jury in.
With those 4 questions all answered in the affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case?
We do not, Judge.
Defense rests?
Defense rests.
All right. I'll see counsel at the side of the bench. The jurors, I think I've referred to the trial as, I sort of see it as different chapters of the book. Another chapter of the book has just closed. And that is that all the evidence in the case has now been presented to you. I remind you at this time, jurors, and I reminded you of this at the close of yesterday, the defense has no burden in this case and has no burden to produce any evidence at all. And that's because, as you probably are all very well aware, the burden lies on the Commonwealth to prove its case beyond a reasonable doubt, and it never shifts from the Commonwealth, right? So what happens next? What happens next is the next chapter we're going to go to as we move toward your deliberations, is that really 2 things that happens interesting.
So my pro se client, you said, I mean, if he were smart at all, he wouldn't go to trial. So I learned that you can't plead guilty to first degree murder. And my guess is they didn't offer him second degree because he could plead a second. Or if they did, they refused to take the plea, which is stupid because he can still be convicted of second-degree murder.
First, I'll explain. There are two things that need left to be done is I need to give you my jury charge, my legal intent. Then you need to hear the opposing arguments of county. So the way that happens is I will give you, when we next reconvene, which is going to be tomorrow morning, and I'll tell you why in a little bit, in a minute. I will give you instructions on the law that's specific to the charge that's crimed here, the charge that the crime that is charged here, murder. Then the lawyers will do their closing arguments. And then I go back and give you additional instructions. I call them more generalized instructions. So those two parts of the trial happen interspersed. A little instruction, argument, more instruction. That's going to happen tomorrow morning. And I try to be as transparent as I can in my cases. The reason for that is I don't just pull these instructions out of the ether, as you might imagine. There are instructions and guide instructions. And I get the input from the lawyers on what they're seeing. And that hasn't happened yet because we've moved at a pretty efficient pace. So I need to do that work with the lawyers today, and I will. And that's what we'll be doing today.
All right. So that is the end of what they say. Okay, you go home, get some rest. Then they go through the jury instructions as they are. The lawyers break so that they can come back with any changes. That is what we're going to look at next. Just because I think it's the only interesting part. My video hasn't removed its silent spaces yet. It's still thinking. So we're going to just have to look at the web browser. We'll be able to change the speed. But here's to be that. So, okay. So have they proved first degree murder yet? Or have they proved that it could be first degree murder? I mean, this is why I was kind of annoyed earlier saying they're skipping over stuff that they shouldn't be skipping. They should be going through everything on that receipt because, as you'll hear later, the closing arguments are limited to 45 minutes. That's not a lot of time. So if I was a Commonwealth, am I focusing on just the murder aspect to make sure he gets charged with at least second degree, or am I going to spend time on the first degree? This is what makes it also more difficult when you don't introduce a demonstrative during the trial. If you're just planning on, oh, we'll hit all this when Brian takes a stand, which he didn't. So maybe that's a good move for the defense in terms of overall, because I think if he takes a stand, he gets definitely convicted of at least second degree murder, if not first degree murder. So I wrote out to Suma and Derek, like what I would say if I was a Commonwealth. This is how I would approach it if I was trying to prove first degree murder. It'd say something like, the witness testimony has stated that Anna wasn't happy with Brian not moving on his federal case. Anna wanted her children in D.C., Brian, if available. Brian researched divorce options on 12/27. He researched divorce scenarios originating from D.C., showing at least a concern of a scenario where Anna originates the divorce herself. Divorcing Anna divorce with Anna leaves him alone with no children, since they would go to Anna since he can't support them, since there was no evidence that he made any money for self-support. He stays at home. And he will have to go to prison because he won't be the primary caregiver anymore. There's no more delaying it. There's no more arguing, hey, I'm the only source of care. I should stay on house arrest. Brian has a mountain of debt he cannot pay, $470,000. If he and Anna divorce, he loses all access to financial success and his life of not working. If Anna were to die, though, he inherits everything, along with the massive insurance payouts. He can pay off his judgment and have a windfall to not have to work. He can continue to argue with the courts that he is a single father and should serve his sentence on house arrest. I mean, aside from the dismemberment charges. It is impossible for him to come up with a reasonable situation where she died without him being blamed, so she must disappear. We see searches on inheritance related to a missing person in his own browser history. We do not see any searches about natural death. We do not see any calls to 911. There is no mystery of how Anna died for Brian. The only problem he is focused on is trying to clean up all the evidence of what he has done, because however easy he had originally imagined killing Anna to be, it turned out to be much more complicated and messy. He planned to spend the first getting rid of Anna. He wrote to his probation officer requesting a block of time to help his mother that evening, which he didn't do. He didn't alert the probation office that there was no school on the 2nd, so he wouldn't be leaving home because he was planning to use that time as well. He had told Jim when Anna was alive that his phone was missing when it wasn't, because he knew he would need an explanation of why he could be seen moving around without his phone. But he needed more than the first to clean up Anna. Brian underestimated how messy murder is. Whatever original manner he had planned to kill Anna, possibly strangulation, maybe if she's found when he places her out in like the wilderness or in her car, blaming it on, a lover. Maybe it was her lover, Richard. I don't remember what his name is now. Mr. Fastow. That could be something blaming a stranger if she's found, but it didn't work out the way. Whatever he did, he knew he couldn't claim it being an accident. We see him searching for removing DNA from a knife. He used his extensive searches for cleaning up blood, and we see searches for how long a body needs to decompose before it starts smelling. He knows he needs time because Brian believed Anna's body could no longer be found, and he wouldn't be blamed. It would be too obvious that that she was murdered. This is why he begins searching for dismemberment only after the murder. We see him shopping for cleaning supplies through the 4th. Only once he believes he has cleaned up the scene and disposed of Anna's body and all the tools of dismemberment in multiple dumpsters. This is when he starts to report Anna missing, etc. Okay, that's the William Fastow, not Pastow. That's where I would hit on it. That proves premeditation through circumstantial evidence, right? But it's going to be hard in 45 minutes when you didn't weave any of this together during your presentation of evidence. So if Brian gets off, it's on the Commonwealth. They had everything they needed. But let's watch now the debate on the jury instructions.
My approach to charge conferences is pretty informal. And so what I'll ask for each of you to each side is, based on your initial review of the draft, where's the first page that you wish to be
I'm going to speed it up. It's 1.5 right now.
bring something to my attention because you either don't want it in there or you want it in a different way. So an edit or an extraction or an addition. What's the first page for the Commonwealth?
Your Honor, I'd say page 15 going into 16, the impeachment by prior conviction.
All right, stop right there. And does the defense have anything before page 15?
Yeah. What do you think? They're obviously going to have some problems.
Page 1.
Page 1.
She just took it.
Are you joking?
No, it's, I'm sorry. Premeditation. I'm sorry, I have it 1 here, but I meant what my notes are saying, it's paragraph 1.
I said page 1 is the index. Actually, it's not really page 1.
We need it forever if we start with page.
All right, so what page?
Page 6, and I'm just lodging my objection, Judge, to, otherwise the instruction complies, in my opinion, with the model theory. I'm renewing my request for my modification that I filed on behalf of defendant's request for jury instructions concerning conscious detailed emotional evidence and bad acts. Paragraph 1, I'm asking that the section be regarding the timing of premeditation be removed for the reasons I stated in the motion.
All right, I read your motion.
So basically, he doesn't want it being, hey, premeditation can occur a second or an instant before it's done.
Denying your request
Right? He wants it to be like, oh, you need like a week to prove that.
to make the change. As you know, if I agreed with you, I guess the underlying premise that I thought there was something wrong with that instruction, I agree with you. These are just model instructions. Now, they're model instructions that people have spent, I don't know, countless hours assessing the propriety of, but I don't think that instruction is improper in any way. I think it's a proper instruction, and it's one that ought to be given in this case. So I won't modify the model SJC instruction with regard to the request, but it's been fully preserved for the appeals court if they decide to change the instruction.
Thank you, Judge.
So 15 on to 16. Anything from the defense before page 15, other than what you just mentioned?
Page 9,
Yes, counsel?
the instruction, parentheses B,
Yes.
use of a dangerous weapon.
Okay.
I think that's in the context.
So here again, this is where I will disagree with, I mean, obviously they're trying to argue this, but this is laughable, right?
In circumstances of this case, that instruction is very prejudicial and misleading. There is no evidence no direct evidence or circumstantial evidence that there was a weapon used that caused the death of Anna Walshe.
Well, there's a lot of blood, sir. There's also your client's search for getting DNA off of a knife, even though no evidence of a knife containing DNA was in there. We have the search of him asking how to get rid of it. Please, sir, spare us this ridiculous nonsense. This is, I don't know.
And
What do you guys think?
so what the jury is being allowed to do.
What about the breadcrumbs that the Commonwealth put down?
There were more than breadcrumbs.
Well, why don't you argue, then I'll let them make, I don't want to make their argument for them. That would be, but I want to get to the right answer. So go ahead and you argue, and then they'll argue, and then you'll have an opportunity to rebut.
I understand the admission of the exhibits. And I understand the admission of the hacksaw. But to suggest to the jury that they can just pick and choose whatever, quote, weapon, even if you can define it that.
But he gave them so many options. And he searched about the knife before he bought everything else. Now, they're going to hit on it for a different reason. But he searched about the knife before he bought all the other tools. So that's clearly a murder that can be inferred.
And just speculate as to, well, this was used, this wasn't used. That is requiring the jury to speculate that a weapon was in fact, in the first instance, that a weapon was in fact used when there's no evidence of that. And secondly, to speculate that some of the evidence that was introduced might have been a weapon that was used without any evidence that in fact it was. And given the state of this evidence, this instruction invites the jury to speculate without sufficient evidence to reach its conclusion. And I would ask that it be removed because all it does, well, I'm repeating myself. I'll leave it at that.
All right, Commonwealth.
Your Honor, it suggests from the evidence it's a reasonable inference based on the safari history and the searches regarding getting DNA off of a knife, using a dishwasher to remove DNA. One can infer that an object was used, a dangerous weapon was used to murder Anna Walsh. There's also the evidence of the defendant's trip to the Vin and Liquors dumpster when the liquor store was closed. I believe the manager of the liquor store identified it as the defendant throwing that bag in the dumpster. That's prior to the trip to Lowe's or any of the stores where he purchased the materials. I would suggest it's a reasonable inference that a dangerous weapon was used here and would ask that the court keep that instruction in.
Yeah, that's right. That's right, defense. I mean, they brought up the fact that he threw away the bag, but I was already calling on day one. He had the knife searched before he went and bought the stuff the next day.
I might have misheard, but I thought I heard she said say DNA on the knife.
No, she didn't say that.
No, your client said DNA in a knife. Your client literally searched how to get DNA off a knife.
Because there is no DNA on the knife, right?
That's correct, Your Honor.
So, but I did hear you say knife, didn't I?
No, I didn't hear her say knife just now.
There was
Well, she did.
a search.
There is a knife above the,
There is a knife, but there is also a search in the web history in the defendant's.
I remember that. And
regarding
it was, the search was specific as I recall it, and remind me if my memory is wrong. Is the search with regard to the dishwasher specific to a knife?
No.
Your Honor, may I? I believe that I can answer this question. There is a slate.com article
Right.
that the defendant went to that was regarding getting can DNA be removed from a knife.
Yes,
Then the dishwasher is
following that, right?
follows that, and it's can the dishwasher, and I'm just trying to find the exact words.
Give me the page number on the, I think it's Exhibit 79, is that right?
It's Exhibit 79.
All right,
And then page number 4, the DNA off of a knife,
yes,
is page 578.
let me get there.
Okay.
I'm there.
Okay. Then if you go to page 670,
Hold on, I just want to look at these.
sure, I apologize.
How long does DNA last? Is it possible for DNA to take DNA, clean DNA off of a knife? And that's done on 1/1/23 at night.
I mean, he says knife. He didn't say toothbrush, towel. This is like the Brian Kohlberger thing, right? Well, his DNA is only in one spot. Yeah, on the knife sheath. And they were stabbed to death. It's not on a remote. It's not on an alarm clock. It's not on a kitchen baster. He's asking about knives. DNA off a knife.
9:34 a.m.
Yes, Your Honor.
Okay, just putting all this evidence together. When was the Vinton's Liquor is also on the first? It's at night because I remember it being a little dark. What
Yes,
time is
Your Honor.
that?
It's dark at the at Vin and Liquors.
5:30, 4:30.
And unfortunately, defense, your client didn't provide any alternate explanation. So the jury has to and may draw an inference that the knife was used as the murder weapon. It's not crazy speculation.
30, something like
5
that?
p.m., Your Honor.
All right. Okay.
And so if you were to go to page 670,
Yeah. Let me get there. Yes.
and if you were to go to record 2430,
Does a dishwasher clean blood?
yes, Your Honor.
That's at 1/1 at 1:52. Also before the,
Been in liquor.
That's another good point. The DNA, does a dishwasher clean blood? I thought it was DNA.
right.
And then on page 671, There is record 2433. Is it possible that a knife that,
Which the blood on it remains contaminated with HIV after it's been washed with hot water and dishwasher soap.
yes, Your Honor.
Mhm.
And so,
And above it, does a dishwasher clean blood?
yes, Your Honor.
Mhm.
So
He searched, can the dishwasher clean blood? Because he was super lazy. He's like, I don't want to clean all this stuff.
I think earlier you referred to breadcrumbs.
That's what I said.
And so our position would be it's a reasonable inference based on the searches, the behavior of going to Vin and Liquors, and then this is all before the Lowe's trip where the other articles are bought for the purposes of the dismemberment. And if you look into the searches on the second, it's instructions on how to dismember. So there I see what our argument is that those searches show the reasonable inference that a weapon was used.
Yeah, it's pretty clear to me.
All right, there are the breadcrumbs. Attorney Tipton, back to you.
Well, I'm not going to repeat what I said. I understand the breadcrumbs argument. However,
So was the jury, hopefully.
I would ask them, I think I see the writing on the wall, that the instruction will remain, but I would ask them to be fair and balanced, that a sentence be added, that you are not to speculate about whether a knife was used,
What?
or words to that effect to help guide the jury.
You want them to specifically have an instruction that don't speculate that a knife was used? The one weapon that he most likely used? Come on.
To avoid speculating about any and all of the tools and weapons, so-called weapons. I just think the jury's going to think, oh, I can cherry pick whatever I want to and call it a weapon and use it to find the defendant guilty of first.
That's not cherry picking. That is looking at the relevant evidence. Cherry picking would be ignoring your testimony from your client saying, I didn't stab her. She died of sudden unexpected death syndrome. What a load of crock of horse.
Degree murder. And I'm trying to make sure that the jury does not get such a broad instruction that allows them to speculate. So I'll leave it at that.
Well, I'll give some more thought about whether I add some language in there with regard to speculation. And if you wish, you can provide me with some recommended language. But as you know, the whole issue with speculation is handled quite completely in other parts of the instruction. But I'll think about it.
I will send the court, if it's okay, I'll send an email to the court today with suggested language.
All right. As of this time, the instruction is going in and subject to any additional edits. But I think there's enough there that the Commonwealth has presented, as I said, the breadcrumbs.
Attorney Tipton,
But are you suggesting, I just want to make sure I understand what the respective position, which, I don't, this case is what it is. It's been a circumstantial case from the beginning. And so those breadcrumbs are important for the Commonwealth's case. And I think they've properly established it to a sufficient degree to get this instruction about use of a dangerous weapon. But I'm also mindful of what you say. I'll go back and look at the section about the prohibition against any speculation or guesswork and see if I feel like it accurately and completely addresses those concerns. And I'll be open to seeing whether there's something else.
Hello, Blue River.
More easy for the jury to digest this aspect. That's all I can say right now. All right. We're still at the defense. Anything else before page 15?
No.
All right, so now we'll move to the other side. What is your, I'm moving to page 15. Did you say 15 into 16?
The impeachment by prior conviction.
Yes.
No, if he's found guilty of murder, he needs to be sentenced for both. But he's already pled guilty. Oh, you said not guilty of murder. Yes, he still needs to be sentenced for the dismembering and lying to police.
I guess I lifted part of this language from the defense's request.
Your Honor, this appears to have language suggesting a testifying person being impeached.
That's probably because when the defense, I lifted it from your instructions and at a time when I think that was the expectation, but let me go back.
Yeah, everyone was thinking he was going to testify.
Well, that first sentence, they have heard evidence through a stipulation, right? Is it later than that I only read the first sentence so far. You've heard evidence, they have through stipulation, right?
Yes, Your Honor,
That sentence is okay.
it's on the next page only for the limited purpose, and I suggested
I see,
limited
I
purpose.
see, I see.
Yeah, I can't believe he didn't testify either. It's very disappointing. That was the only reason I was really covering this trial every day, even after it was boring after day one, because I was sure he was going to testify. He had to. Based on the opening statements. I mean, this is shaping up exactly like the Chandler Halderson trial, other than the defense actually cross-examining witnesses, right? But they put on no defense because there is no defense. And you'll just be seen as a bigger liar. We better roll the dice, I guess. It changed last night. It changed last night because the defense literally asked about 5 issues in regards to him testifying, like in terms of instructions for the jury prior to him testifying or after him testifying, that they wanted her to research last night, which she did. And then this morning they're like, oh, he's not testifying.
Your Honor, I note in Commonwealth's motion in limine number 12, paper 198, the Commonwealth laid out the purpose for which it was seeking to bring in the evidence of the federal charge. Perhaps that language from that could be substituted, as you may only consider this evidence to understand the relationship between the defendant and the victim, or something of that nature, to understand the complete circumstances of the situation in the home at the time of the events at issue here.
Well, I don't like that.
I think, Your Honor, the model instructions all do seem to include, you may only use this for the limited purpose of, and I suggest they should be given a purpose. And
Well, but it's not impeachment. I mean, I did put that in there last night based on the information I had at that time. But that prior felony conviction is no longer impeaching Mr. Walsh. So it just seems to me like it should be out.
We think it should be out.
maybe it should be out.
I mean, it's no longer impeaching him, and the relevance of the prior federal conviction goes to motive intent, it seems to me, right?
I can't believe closing is only going to be limited to 45 minutes. I don't get that. At least an hour.
Your Honor, I suggest there were reasons it was introduced to understand the relationship in the home as way of a shorthand. So
That definitely
I agree, it's
helps
not
the
impeachment
defense.
evidence.
My present ruling is that's the whole section's coming out now. The reason the impeachment by prior inconsistent statement is now in italics is, I'm sure that happened with some witness, but I'm not 100% sure.
I don't think it did. At least.
Anybody?
I don't wanna speak for-
Your Honor, I think some witnesses may have testified a little bit differently than they had previously and were shown documents. I don't know that it rose to the level of impeachment, but
I mean, yeah, he clearly lies to the police. Getting on the stand, I don't know. Like, it was never going to be
there
good.
was
That's why.
some questioning
Did they not offer him second-degree murder?
of some witnesses about something they had said
Yeah, I
previously.
just don't think that we ever got to a statement. I don't remember anybody grabbing a grand jury transcript and cross-examining. The closest we got to it, I think, was Jem yesterday, Mr. Mutlu yesterday, and that wasn't with a prior statement.
Actually, maybe that's a better question. Let me ask you guys. After you pled guilty, where you could get anywhere from 10 to 20 years for the dismemberment and lying to the police, do you think the Commonwealth could have offered him second-degree murder? And then should he have taken it? I think it would have been justice offering him second degree. And versus risking a not guilty plea. And the defense should have taken it, but that's why it makes me think they didn't offer it to him.
It was his prior statement, but he just said, I don't remember. So was that enough to warrant the instruction?
Certainly, if the defense wants it out, we agree we should take that out.
That is a good point, Luis. I think you put it like that, so it's not Lewis, or maybe I got it exactly wrong. Sorry, Luis. I feel like his defense told him how bad it was going to be. He realized he looked bad and it would be seen on the stand. I think either one happened. Yeah, it could have been that as well. Like they were telling him the entire time, don't testify, even before trial. But then he was adamant that he was gonna, and then they finally were able to convince him last night, even after they put their motions in, and he said, yeah, okay.
I don't.
They probably would have had to convince him that they hadn't established enough evidence for premeditation.
Need to give them more instructions that they're wondering, what the heck is she talking about? So I'm inclined to take it out.
And we have no objection.
All right, that's why it was in italics before.
Your Honor, then the impeachment by defendant's prior bad act.
Yes.
With this, I would suggest that the lying and the conveying of the body are part and parcel of the murder at this point. It's the disposal of the evidence of the crime and the lying about what he had done. I would suggest it's not a prior bad act. It's part of the evidence of the case.
It's an interesting question.
There's many
I'd agree.
interesting questions in this case, Your Honor, no doubt.
It's an interesting question whether
Is it a separate lie to lie about the dismemberment versus the murder, right?
where are you drawing the line of a prior bad act occurring? Can you have a prior bad act that's part and parcel Is it prior to this time? Is it prior to the crime that was charged?
It's arguably subsequent, Your Honor, but,
Right.
I mean, it's arguably,
What about the lying to his federal probation officer?
that would appear to be a bad act, arguably a subsequent bad act, but,
Yes.
I don't want to interrupt. I tried to address what I believe are prior and subsequent bad acts in our pleading at page 6.
Yeah. Okay. Well, you also wanted it introduced.
And I took it from the Massachusetts Jury Trial Bench Book, and I modified it only to accommodate what I believe is relevant and pertinent. And the gist of that model instruction is to make sure that the jury, if they hear what they consider to be bad, and I frame our instruction as prior and subsequent bad acts, that he's not charged with those, and that they have to, just like the model instruction says, if they deem those to be bad or subsequent bad acts, they can only use them for a limited purpose. And I think that this jury will probably be asking themselves, I don't know who in the world wouldn't ask themselves, that's a bad thing to do, if they believe that the body was dismembered, and if they believe that the body was disposed of in bags, anybody's going to think that's a bad act. And they need to be instructed that they can't, he was not charged with anything, and therefore they can only use that evidence in a limited.
What? How can you sit there with a straight face saying he wasn't charged with it? He pled guilty to it. You don't have to mention that he pled guilty to it, but you can't say he wasn't charged with it.
Basis. And I don't much care for the specific language of motive or anything, but it is the model instruction. And I think I would try to parse.
So I'm looking at your instruction right now, and that really deals with the art fraud, right? Are we on the same page,
Yes,
Attorney
we are.
Tipton? But are you suggesting,
Okay, we can switch over to my video now.
are we on the same page,
Yes.
Attorney Tipton? But are you suggesting, I just want to make sure I understand what the respective positions are. Are you
Mine has his pauses cut out.
suggesting then that you want to expand that, so you want an instruction to the jury that includes the language that I have in there, which is lying to the police and disposing of the body of Anna Walsh,
Well,
and the lying to the probate? So that's not what's in here, but are you saying do what you did, Judge, in the instruction, but add what I want in instruction 6? Is that what you're telling me?
yes.
Okay.
But
Do you want that to be included? So in the proposed instruction, and just so the record's sort of clear, I'm talking about the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I don't know what the docket number is, but I got that. It was filed yesterday, December 10th. And I'm looking in particular at your request number 4, prior and subsequent bad acts. That's what you were referring to, Attorney Tipton. Okay. And so in that, as you initially drafted it yesterday, it was about the art fraud, but you're now suggesting that would be an appropriate instruction also for the other bad acts that I've identified in my draft on page 17 under impeachment.
No, yeah, proceed, Klein. I know you're not in the U.S., but these are the instructions that are going to be going to the jury. And there's the draft at the beginning, which is what these are, and then they're arguing on changes for it based on how the trial went.
yes, Your Honor, I was anticipating there to be a proposed other instruction like you had, but yes,
Okay.
I would ask then
So I
that,
think I understand what the ask is now.
Right.
And so now I'll go to the Commonwealth.
Your Honor, I think I understand it better as well. It also says in the instruction about the middle of it, if you credit the statement, I don't know that we're specifically talking about a statement here, and maybe that could be expanded if the court is inclined to keep that instruction in.
Well, I think the language comes
Right, Louise.
in that defendant hasn't been charged with committing any other crimes other than murder. I'm just pausing there because if I move the federal art conviction in, somebody could wordsmith that and says, oh, yes, he pled guilty to a federal crime. Maybe the better way to say it is the only charge
Or
you need to
Lewis.
consider is the
it
present
Lew-
charge of murder. You're looking at the first
Louis or
sentence.
Louise? Is it male or female?
take a
Just
minute.
tell me.
All right. So if I say something along the lines of the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and I wrote a few things in there, and it would seem to me what the defense is asking is that I add, the language that you have in your request was including acts involving a federal case concerning art fraud
Okay,
that he
Louise.
was charged with in 2018 and sentenced in 2024, comma. I'll just put them in date order, right? Lying to the
And thank you to everyone who's been sticking with this incredibly boring trial. I know I've cut it down for you, but also you're still subjecting yourself to it. And I will have to leave in about 45 minutes for a band concert, but we should be able to finish before then.
police. And
I thought you said you were out of country. I thought you said you're paying in your Dutch krooners. Okay, you're in the U.S. Oh, you're in Orange County? We should have hung out. Why didn't you contact me, bruh?
or disposing of the body of Anna Walsh and or lying to his federal probation officer. So all 4 things would go into that parenthetical. Okay. And then I would pick up with what the defense says. You may not take the defendant's prior acts as substitute proof where they committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. And then the rest of that, you see that all there. All right. What do you think about that, Conwell?
Will the court be removing the, but if you credit the statement sentence?
Yeah, no, what I would do is, I'd make the change that the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant,
Yeah, that's why I'm early tonight.
namely,
It was either this or be really late, like 9:30, 10 p.m. Pacific.
and then I would go,
Yeah, right. That's all they really got to highlight in the closing statement, like the theoretical one I gave you. Right? He doesn't search for natural deaths. He doesn't call 911. No person in their right mind is going to. I mean, that's the other thing. I don't think they can argue this necessarily in the closing argument, but Brian needed the money, right? If all of his problems are solved with Anna being dead of natural causes. He can call up the police and say, I didn't kill her, and they can examine the body and everything. He gets the inheritance. He could pay off his debt. He gets to keep his kids. His wife isn't leaving him for another man. His wife isn't taking the kids away from him. He doesn't have to work. The idea that you would then dismember the body after natural death is so ridiculous. It begs to strain any credibility of the argument. I grew up in OC and left country at 18. Unfortunately, I can't go back to Florida because I had a pretty traumatic childhood there and suffers mental health from. Okay, so you're not in Orange County anymore. Okay, you grew up there. Got it. And left the country. Okay, so you're not in the U.S. Okay. What did I get wrong then?
to the defense's suggestion, namely, acts involving a federal
Am I supposed to believe that you learned all the intricacies of the U.S. justice system before your 18th birthday and moved away?
case concerning art fraud, and that he was charged with in 2018 and sentenced in 2024, semicolon,
Yeah, that's right. You said you were in Hong Kong.
lying to the police, semicolon, and or disposing of the body of Anna Walshe, semicolon, and or lying to his federal probation officer, end parentheses. Then pick up with the defense's request and follow that
Right. If the defense tries to say, I don't think they're going to say naturally died. They're going to say there's no proof of premeditation. That's what they're going to hammer on more than anything.
through the end. You may not take blah, 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 right through to, it would be extremely unfair to consider this evidence for those purposes. That's where I think I'll end it.
So you're not,
Then I go back. I don't think that's appropriate to add the for one thing.
the last two sentences.
That's right.
I will just say, Jeff, that those sentences are contained in the model instruction at page 343.
I'll take a look at it, but it seems to me then if I put that thing in there, then I've got to, I don't know what I do.
What's the
Those
part?
sentences,
Then I go back, extremely unfair to defense's request and follow that through the end. You may not take blah, 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 right through to, it would be extremely unfair to consider this evidence for those purposes. That's where I think I'll end it.
so you're not,
Then I go back. I don't think that's appropriate to add the for one thing.
the last two sentences.
That's right.
I will just say, Jeff, that those sentences are contained in the model instruction at page 343.
I'll take a look at it, but it seems to me then if I put that thing in there, then I've got to, I don't know what I do about the other things.
Oh, they did, Louise? Is that coming up?
You can see the issue that raises.
Your Honor, there's also the possibility that maybe this instruction should be given around the same time as the consciousness of guilt, because it almost seems, I don't have them both right in front of me, but it almost seems like we might be telling the jury different things about how they can handle the evidence of lying to police and the conveying of the body of Anna Walshe.
Well, that consciousness of guilt is before here, isn't it? Maybe?
I believe it's on page 27.
Okay, so my pro se client, you're all over the map. My family are from Hong Kong, and I went to college there for free. I live in Denmark. International man of mystery.
Well, I had this all in this section because I thought I'll put the 3 impeachment things, but now 2 of them are gone. So it doesn't make any sense, I suppose, standing alone. Maybe we just go straight from witness credibility to experts, which makes more sense, and move this impeachment paragraph later in the instruction.
Okay, my pro se client.
What do we think about putting it either around the vicinity of the consciousness of guilt instruction?
Well, my comment would be objection to the consciousness of guilt. So
I know you are. It seems to make more sense in that area. So I'm going to move it probably before or after the consciousness of guilt instruction, somewhere in that vicinity. And if you have any strong preferences, let me know when we get down to page 27, recognizing you don't want it at all. But I'll edit the impeachment to include a substantial portion of what the defense has requested and add in specifically the federal case. That's all I can tell you for now. To be continued on tomorrow if we need to discuss it more.
and I understand the court's not going to include the last we saw this log.
Okay, so lodged. What's the next edit that the Commonwealth has?
Commonwealth has page 27.
What's the next edit the defense has? Nobody likes penny track. He said, what did I do on that page? Let us see. Okay. That's COG. Who wants to go first with what I got wrong?
Your Honor, I would suggest here in the italicized language,
Yes.
in the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest, and that he may have taken steps to conceal the disposal of Anna Walsh's body. I would just suggest that should be tried to conceal the disposal of Anna Walsh's body. And in the...
Well, the fact that it was unsuccessful is something you can argue. I mean, there is some evidence that he may have taken steps, right? That's not inaccurate.
Correct, Your Honor, that's accurate.
But what do you want me to add?
I was thinking you could subtract some words and perhaps make it more concise, but that is certainly...
All right, so what do you want me to subtract?
Rather than saying taking steps to conceal the disposal of Anna Walsh's body, it's tried to conceal Anna Walsh's body. It's not so much that he was concealing the disposal of it, he was concealing the body itself.
So you want me to taken steps to conceal Anna Walsh's body after death?
Yes, Your Honor, because it's the body itself. It's not so much the concealment of the body, but it's the steps to
conceal the body, not the disposal of the body.
Yes, Your Honor.
All right, that's probably more accurate. So under the Commonwealth's request, I
We
would
do not
delete
know
the three
who the
words,
kids
the
are with
disposal
Kit
of.
Kat, yeah.
Will you add the word try?
What do you want me to add?
Try. I thought I heard the Commonwealth asking for try.
Commonwealth's content with how the court articulated the...
Well, attempted to take steps might be consistent with the evidence, but then that puts my thumb on it a little bit because it presumes that that was evidence of her body.
All I was responding to was the Commonwealth suggested the word tried. I think that is more consistent, but the evidence shows. I'm just talking about tried, not waiving any argument to the contrary.
All right, I'm going to leave it like it is with the removal of the disposal of. I don't like the tried part.
In the next paragraph, Your Honor, in the italicized, defendant did attempt to provide false information. I believe it would be did provide false information.
Yeah, no doubt.
And there I got the language right in the second attempt in terms of what you just pointed out in the earlier paragraph. Even a blind squirrel finds a nut every once in a while. All right, any other edits to that?
No, throwing the trash is disposal of. What they're saying is it's not attempting to cover up the disposal. You're trying to cover up the body. That's what they were hammering on.
That consciousness of guilt instruction, recognizing the defendant doesn't want it, and that objection is noted and lodged.
Are you done?
I think she's done.
So once again, I refer to our prior pleading, and on page 4,
Yes.
I'm asking that be included. And I modeled that, trying to find the citation, I modeled that after what I believe to be the gist of a supplemental instruction 9:22, and it's the district court. And the heading for that supplemental instruction that's included refers to where evidence is of it, where such evidence is of another crime. It goes on to say, I caution you in considering such evidence that the defendant is not on trial for, then it has a blank.
Right.
And that's what
But now that I'm moving down the other section that we just discussed, which far more in a more detailed fashion addresses that.
You mean in the prior?
Yes, because now that's going to sit right on top of this one.
Well, but I think that the reason I'm pressing this, notwithstanding other instructions, but I think just the title alone draws attention to the jury, where they're hearing a different instruction entitled consciousness of guilt. And I don't know that jury will take some language from a prior instruction and import it into this one. And it's important for them, in our opinion, to have context for how they use so-called consciousness of guilt evidence. And the other thing is, when you talk about consciousness of guilt evidence, the case law is clear, and the instruction says they can't rely on consciousness of guilt evidence alone. And I think then, since we don't want the instruction in the first instance, at least it gives them better context for how to apply what they may deem to be consciousness of guilt evidence, especially where you hear all of these other acts. And yes, they will get the prior bad acts if you juxtapose it before this instruction.
I actually think it's better right after it, as I'm thinking about it, because it leaves them with it puts them in that moment, and then you may not use it for this purpose. As you were arguing, I'm like, that's not going before, it should go after, because
The supplement is primarily based on this Model 9.
I'll go back and look at it, and I'm going to see how it feels once I've moved things around and how it reads. All right. And of course, you know this is coming, so you will, I'm sure, as you all, I know you will. You're going to take those parts of my instructions that you want to highlight to the jury and put them in part of your closing argument. And so you'll know where it is, and you can point directly to it so that you highlight. I'm going to tell them, take all my instructions as a whole. You're going to drill them into the ones that you think best suits your client's argument, including this one. But anyway.
I may, but
or not.
Having said that, I guess I just want to ask a question.
Yes.
Does the court intend to supply written instruction?
So what I do is I don't give them a written instruction during the actual charge. And there's a very simple, I'm a very practical person. I've been sitting on the bench now since 2017. And not once, and I'm not proud of this. There are other judges that do a better job at this. There's not once, no matter how many times I read this, no matter how many times you read it, there's always a wayward S that sticks in there, charges instead of charge, or some other less than perfect product as I read it. And I edit those on the fly, and I tell them, typically it's my oral instructions, not what you put in the writing. I've never had something that's been a huge guffaw, but it could happen. I don't think it's going to happen in this case, but I don't finalize those instructions until after I've read it to them, made those edits. And it's sort of a running game I have with myself. When are you going to get it right? Exactly right. Hasn't happened yet. I don't know that it's going to happen on this case. There's always some little niggling little mistake. So I don't give it to them in writing when I'm reading it. I give them copies of the charge when the exhibits go back. And my practice has sort of varied over the years. I used to just send in one because I want them around the table talking about the instructions, doing it all together. That became cumbersome. So I've now changed it to I usually send in 5 or 6 copies of the charge. If they want more, they can have more. I usually tell them that. But I won't give them, they won't be sitting in the box reading the charge with me. That's not how I do it. And that's the practical reason why I don't do it. I don't want to be backpedaling. I want to give them the best product, both orally and in writing that I can give them. So if that answers your question, that's how we'll do it. Now you'll obviously have the draft so you can read along. And I encourage you to point out my errors despite my best efforts. You'll see me up there marking it up as I always do. Maybe tomorrow will be the case that I get it all right. Still trying. All right, what's the next page?
Your Honor, for the Commonwealth, not so much a page, but circumstantial evidence. I know the court has direct and indirect evidence in there at 23. Would the court consider also including circumstantial evidence in that?
What page you on?
Page 23?
Oh, this is the plain language version of the circumstantial evidence.
Yes, Your Honor.
Switch to the next one.
On feelings about it. If there's some language you want to propose, I have used other language that refers to things as sort of the more old-fashioned language. This is direct evidence. The mailbox postman thing. I've delivered that a number of times. I think this is the more modern version of that. But if you want to propose some language, I'm not adverse to explaining.
Just objecting to any additional language, and I'll wait and see what they propose.
All right.
I think that
It just talks about it in terms of direct evidence and indirect as opposed to circumstantial. I mean, it could be as simple as adding in sometimes called circumstantial.
Yes, Your Honor. With permission of the court, could the Commonwealth submit something later today?
Sure, that'd be helpful.
And if they do, which it sounds like, I'm going to then add, just to let the court know, an additional language as for inference that hopefully will counter what they're trying to do. But I'm just giving the court a heads up. I don't want to send you something and you would ask.
What if I just say that is indirect evidence, sometimes called circumstantial evidence, and then you don't have to do anything this weekend? I mean, not this weekend. It feels like this weekend. Then you don't have to do anything tonight. I'm going to suggest that, but you can do what you want. All right. Anything else on the instruction?
Not from the Commonwealth.
All right. I really didn't mean to set off well, there's a word that comes to mind, but it wouldn't be judicial, so I won't use it. When I made my comments this morning about closing arguments. So let me just say, I'm always trying to stay a step ahead of you. It's not easy.
I was, but I said it would be either early or late. Yes, sir.
And so I did start looking at this issue a couple of days ago. And I'm going to tell you what the cases I came up across and sort of where my preliminary thinking is with regard to this. And maybe there isn't an issue. Maybe there is. But let me just tell you, we all know what I'm talking about, right?
Yes.
All right. So I'm going to give you some cites to some cases, and I'm going to tell you preliminarily where I think the line drawing is. And it's really preliminary because I looked at these like 4 days ago. No, Tuesday, December 9th. So I guess it was just yesterday. Well, no, that's not exactly when I looked at them. I think I looked at them this week, and I sent them to my law clerk on Tuesday, December 9th, or vice versa. So anyway, here are the cases that I want you to take a look at. 2019, Commonwealth versus Ahern, 96 Mass App Court, 197. And that cites to Commonwealth versus Nelson, 468 Mass 1, a 2014 case from the SJC. And I also want you looking at Commonwealth versus Tavares, 27 Mass Appellate Court, 637. And in those cases, the SJC and or the appeals court is really talking about this issue of improper burden shifting and avoiding that in closing argument. And really, it seems to me the one that's the closest to this is a combination of Ahern and Nelson. And look at those cases. I'm not going to get into a detailed description of what I think the similarities are to those cases. You're going to see it when you read those cases. But it seems to me preliminarily that while the Commonwealth should not comment that the defendant didn't testify, that would be improper. It seems to me that they could point out that there's no evidence that Anna died of any natural causes. I read the pleadings that just came through. And if that is where the line is drawn, and you don't have to respond to this right now. I'm not, and frankly, the pleadings that just came through, I mean literally the ones that came through before the defense filed right before I went on the bench. I'm not sure where the allegations of reneging on a promise are impacted, but I'll qualify that by saying I read the pleading quickly and thought to myself, well, I didn't mean to start that. Back to how I opened this discussion. So that's where I think the line is drawn by those cases. And knowing that's where I'm drawing the line, take a look at those cases and we'll discuss it again before the closing arguments.
Thank you, Your Honor.
Just to be clear, I think and we'll read the case, but what the court's saying is that you would think the Commonwealth could comment that something about
that there is no evidence that Anna Walshe died of natural cause.
and of course the defendant can make I just want to be clear about this because I think we might reach some common ground here.
That's what I'm trying to achieve.
And
Let me hear that again. There
Back
is
to
no
myself.
evidence that she died of natural causes.
Well, I didn't mean to start that. Back to how I opened this discussion. So that's where I think the line is drawn by those cases. And knowing that's where I'm drawing the line, take a look at those cases and we'll discuss it again before the closing arguments.
Thank you, Your Honor.
Just to be clear, I think and we'll read the case, but what the court's saying is that you would think the Commonwealth could comment that something about
That there is no evidence that Anna Walsh died of natural cause.
and of course the defendant can make his, and I just want to be clear about this because I think we might reach some common ground here.
That's what I'm trying to achieve.
And I'm responding to something that the Commonwealth represented. I'm not going to go into right now. So let's just stick to this, if we may. So the government's allowed to say what you just
What I just said.
And of course, the defendant can argue there's no evidence that there was any homicide or any.
Expect you're going to.
I shouldn't be here, I suppose. But I can once again recite the evidence of sudden unexpected death that came into evidence.
That's a little complicated because there's absolutely none of that ties it to Anna Walsh. There's no testimony before this jury that ties sudden unexpected death. That's a little
What does he
complicated.
want here? He wants, oh, can I just talk about the unexplained death?
And of course, the defendant can argue there's no evidence that there was any homicide or any.
Expect you're going to.
I shouldn't be here, I suppose. But I can once again recite the evidence of sudden unexpected death that came into evidence.
Why?
That's a little complicated because there's absolutely none of that ties
You didn't have any experts testify. None of it linking to her.
it to Anna Walsh. There's no testimony before this jury that ties sudden unexpected death to Anna Walsh, is there?
Judge, when the court asks me, my response is the government's case is, using that phrase defense attorneys like to use, it's built on a house of cards, suggesting that a homicide occurred without any direct evidence of a homicide. And so another causation of death should be fair game to argue because it's equally consistent.
No, it's not.
That Eremos and Toft, if you have two equally inconsistent propositions, neither have been proved by reasonable doubt. There is no direct evidence of a homicide. And building on that, we've always said there's no direct evidence that anything that came into evidence, the acts of disposal, the acts of the use of tools, occurred after the death of Ms. Walsh. So why is it that the Commonwealth is allowed to ask the jury to speculate?
Because they produced evidence, sir. They produced evidence.
Based on their circumstantial evidence. I shouldn't use the word reach some conclusion based on nothing more than circumstantial when there's no direct evidence of a homicide. And we can't,
They can met out their burden with that circumstance. The law is clear there. They can met out their burden purely with circumstantial evidence. They can. And their circumstantial evidence with regard to the death, again, are those breadcrumbs and what they're going to argue those breadcrumbs mean from another, the other distinctions in the evidence.
all of which, as we've always argued, came after any death. And so the issue is, what is the manner of death? And we now have evidence that from their own medical examiners, that death can occur suddenly, unexpectedly, without injury, and it's up for the jury to decide.
Yeah, it just says, Carolina pointed out, the medical examiner says you need to examine the body to determine that.
If they can, what evidence do they have as to manner of death when the real possibility, if not probability, is sudden unexpected death due to natural causes, as Dr. App, and it's equally inconsistent with homicide. All we're saying is they don't have any direct evidence of homicide. So why do they get to argue based on their circumstantial evidence when their circumstantial evidence really could only speak violence to conduct post-death, where the death was not a homicide?
But there's evidence in the record before this jury that
I don't interrupt, but there was no objection whatsoever to the entire cross-examination of Dr. App. All of that testimony is before the jury. It's not like we represented that, we made some representation that we will present evidence later, and so we made a date.
Yeah, you did.
you can make an argument based on circumstantial evidence. That's what they're going to do in their case. I presume, I don't know what the Commonwealth's going to argue. I presume that they are going to draw a line between some of the evidence that was.
But again, this is what comes down to the poor practices of the Commonwealth. The Commonwealth should have got up, redirected, and said, hey, if you don't have a body, you can't determine sudden death syndrome, can you?
Retrieved from the bag.
I hate to say I told you so, Commonwealth, but I was screaming it.
As being circumstantial evidence of things that happened before the dismemberment.
I agree.
So, for example, the slipper, the blood in the hair. I presume their argument is going to be that that happened before. That's circumstantial evidence. Because once the foot covers are purchased, presumably they were purchased, it's a reasonable inference to be drawn, they were purchased to be used.
The prosecution's like, I'm going to write that one down.
That's evidence of something that happened before.
I think that's an argument.
I think that's an argument to be made based on the circumstantial evidence that's presented. But so I'm turning to you and saying, if you want to argue to the jury that there was circumstantial evidence that Anna Walsh died of some natural causes, I'm just asking, what's the circumstantial evidence upon which you base that argument?
That somebody said it exists, Your Honor. Weren't you paying attention? The experts on the stand said it's a thing. Therefore, it's circumstantially correct. Come on.
Our argument fundamentally would be that all of the evidence that the government suggests was evidence that was created in the context of a homicide. There is no evidence that it was not after a death. And so, since the jury heard all about the not only just the possibility, but the probability that there is sudden unexpected death, that the jury needs to decide for themselves. Could it have been sudden unexpected death? And all of that evidence that the government is arguing is evidence of a homicide could be only evidence of an attempt to conceal evidence that a person using the
No, it's not. The judge just highlighted where it's not. The fact that he bought the Tyvek suit and there's blood all over this slipper. The fact that he's Googling how to get blood off a knife before he goes and buys the tools and starts talking about dismemberment.
the language and conscience of guilt. A person is acting in a way not out of conscience of guilt, but out of fear or fright or anything.
No. I mean, it should be very easy to do this closing argument for the Commonwealth, for prosecution. The evidence that we have that occurred before the dismemberment, before the tools, before all the cleanup items were purchased.
So why is it that given the state of this evidence, we can argue our inferences that we believe the jury is allowed to make if they so choose, and if they decide that that evidence of concealment was evidence of a man doing. Well,
in this case, Carolina, why not just get a divorce? It's because he owes $500,000 for his fraud conviction. And Anna has all the money, and Anna's the one working. If they get divorced and the kids go with Anna because she's able to support him, then he has no kids, then he can't argue for home confinement. That's why I didn't get a divorce.
Reacting innocently and not with a guilt.
The better question is, he created this situation himself by his own crimes before, right? Wasn't like they had a mountain of debt cumulatively based on some judgment they faced together and he was getting stuck with his half. He doesn't work. He doesn't do anything. I'm going to back up some because I want to hear this bullshit a little bit more.
Potential evidence that Anna Walshe died of some natural causes. I'm just asking, what's the circumstantial evidence upon which you base that argument?
That our argument fundamentally would be that all of the evidence that the government suggests was evidence that was created in the context of a homicide. There is no evidence that it was not after a death. And so since the jury heard all about the not only just the possibility, but the probability that there is sudden unexpected death, that the jury needs to decide for themselves. Could it have been?
Nowhere was it stated a probability. Your argument's a probability because she didn't have any apparent health issues, and so she naturally died, so it must be sudden unexplained death syndrome. No, sir, that does not make it a probability. What makes it less likely is the fact that your client had motive and cut up her body.
Sudden unexpected death, and all of that evidence that the government is arguing is evidence of a homicide could be only evidence of an attempt to conceal evidence that a person, using the language and conscience of guilt, a person is acting in a way not out of conscience of guilt, but out of fear or fright or anything of the sort. So why is it that given the state of this evidence, we can argue our...
A lot of opinions limited because they didn't want the Commonwealth didn't want the jury to know about those guilty pleas, because then it could be something like, oh, well, yeah, maybe he just did dismember him. We don't know if he killed her, so we can't agree.
That we believe the jury is allowed to make if they so choose, and if they decide that that evidence of concealment was evidence of a man reacting innocently and not with a guilty conscience, then how did Anna Walshe die? Maybe she died a sudden, unexpected death, and he tried to conceal it out of fear or fright, as is contained in the language of the conscience. And so the jury...
That doesn't make any sense. It does not make any sense to a regular person that you'd be afraid if your spouse suddenly died, that you'd be blamed for her murder.
Gets this, and certainly the thrust of that argument is they're reasonable, and that's the evidence the jury heard.
Your Honor.
Listen, they may not want, I'm not precluding you from making that argument right now. And in fact, they probably...
Polynomial purebred, $1.99. Nah, limbs just fall off torsos all the time. Yeah, I know. I have trouble keeping my limbs attached.
probably want you to make that argument. I'll hear from the Commonwealth.
Sorry for interrupting, Your Honor. Your Honor, this started out with a motion that the Commonwealth not make any reference in closing to representations by counsel in opening statement. The Commonwealth does not intend to burden shift. The Commonwealth does not intend to refer to matters not in evidence. There certainly was testimony from the medical examiner talking about different ways people can die. The Commonwealth is certainly entitled to comment on that testimony, which is in evidence, but the Commonwealth is not going to comment on the opening statement.
All right.
That's why I was thinking we might find common ground.
Sounds like we have.
So as long as we're able to argue that a possible manner of death is sudden unexpected death, I understand that the government's going to stand up and say nonsense. And we're going to say homicide, nonsense. Have we found common ground?
I think we have.
I think we're close.
Just keep talking. I don't need to be part of this conversation. I've directed you to the cases why I think they could say something short of commenting on your opening statement. And I've told you what I think they could say. And just be talking to one another.
Thank you, Your Honor.
So that there's no surprises.
That's true.
All right. And again, I did not mean to create a whirlwind of activity by my comments. I just think that the idea that they couldn't comment at all about the state of the evidence, I didn't want to leave it there. And maybe the takeaway is I should stop thinking about these things 3 or 4 days before they're going to happen. but you have the cases now. All right. Take a look at the verdict slip. It looks very straightforward to me. I don't think that there's going to be any edits or changes to it. Again, I'll finalize that at the very end, so you'll have plenty of time between now and then to look at it. How long are the parties thinking they're going to need for closing arguments?
More than 45 minutes.
All right.
That's good, Your Honor.
So 45 it is. I won't cut you off in a case like this, of course. I have cut off in other cases when it's a 2-day case and we're at 45, 47, but that isn't this case. And, but just, I know you'll all have a ton of experience, but 45 minutes is about as much as they can take, effectively, in my view. So let's try to keep it to that. But we will be getting them fresh in the morning, which is good, as opposed to having, a couple hours of evidence in the bank and they're already tired. That's all I have on my agenda. Anything that you need.
And that is it. So tomorrow we get closing arguments, maybe a verdict. Possibly. It'd be nice if there's a verdict and then we don't have to deal with this next week. In other news, there is the release of the 2010 full Diane Downs parole hearing that just got released by Diane Downs TV. And we are definitely wanting to cover that this weekend, maybe Saturday or Sunday with Sumit and ex-Derek. So, yeah, hopefully that can be it. I mean, if we can wrap up this trial tomorrow, that'd be great. That'd be so great because I do not enjoy this. I do not enjoy the stupidity of Bryant. I do not enjoy their defense. Just let's get it over with, people. Yeah, I don't know that they can argue in good faith that she was still alive, Northwest NW. The defense can't. Okay, everyone. I'm off to a band concert. Thank you, everyone, for being here. And have a good evening. All right, bye.